Hey guys, my name is Maria, I'm from Greece.
My name is Kay and I'm from Indonesia.
My name is Lizzie and I'm from Germany. Today's evaluating question is, should euthanasia be legalized? And in this video we will be discussing the controversies surrounding this matter via case examples and provide an in-depth description of euthanasia.
In 1996, Bob Dent was the first man who died through physician-assisted suicide. After years of suffering from prostate cancer, the right of the Terminally Ill Act of Northern Territory allowed him to painlessly end his life.
Euthanasia, from Greek and thanatos, meaning good death, is the practice of ending the patient's life to relieve pain and suffering. In the ancient Greece, euthanasia would also mean the heroic death in the war.
Nowadays, there are four types of euthanasia. The physician-assisted suicide, meaning that the physician would provide the patient with a deadly drug. However, the patient has to inject it himself. If the physician injects it, then it constitutes active euthanasia. If the patient is depending on life support machine and the family decides to terminate the support, then it's considered as passive euthanasia. Providing pain-relieving measures which allow the death to occur without a direct intention, result, and action refers to indirect euthanasia. In order to end unbearable suffering and to ensure human dignity, euthanasia should be legalized.
In different legal systems, different legislations are applied, so in many countries, euthanasia is still considered illegal. Such cases are the case of Tony Nicholson, where the court decided in opposition of his application. Tony was paralyzed from the neck down after suffering a stroke in 2005, enabling him to speak. Tony was an outgoing and active man with a busy and active family, working, and social life. Nevertheless, after 7 years of suffering, he lodged an application to end his life via euthanasia. But the court denied his demand because it was illegal under the domestic law. However, Belgium has a different legal approach in this matter. In the case of Mark and Eddie Verbessem, the twins were both born deaf and lived their life together. After being told that they were going blind, they could bear not seeing each other, so they decided to bid for euthanasia. After many tries, the application was accepted. According to Article 1 of the Belgian Act on Euthanasia, the physician who performs euthanasia commits no criminal offense when he or she ensures that the patient is in a medically futile condition of constant and unbearable physical or mental suffering that cannot be alleviated, resulting from a serious and incurable disorder caused by illness or accident. Moreover, to ensure the correct use of the law, Article 3 of the Act states that if the physician believes the patient is clearly not expected to die in the near future, he or she must also 1. Consult a second physician who is a psychiatrist or a specialist in the disorder in question, and inform him or her of the reasons for such a consultation.
Another example of countries legalizing euthanasia is Switzerland. Even though based on the Swiss Penal Code Article 115 that states that on any person who, for selfish motives, incites or assists another to commit or attempt to commit suicide is, if that other person therefore commits or attempt to commit suicide, liable to a custodial sentence not exceeding 5 years or to a monetary penalty, making the active euthanasia illegal. Therefore, there is a loophole in this article where people can be granted access to assisted suicide on condition that the person whose wish is to die performs the fatal act, that he has his decision capacity, and that the assisting person's conduct is not selfishly motivated. In comparison to France, where euthanasia is still prohibited by the domestic law, a remarkable case regarding this is the case of Lambert and others v. France, where Vincent Lambert was in a vegetative state for over a decade following a road accident in 2008 where he suffered several brain damages. The man's parents argued that terminating the life-sustaining measures constitute a breach of Article 2 of the European Convention of Human Rights, whereas the wife, Rachel Lambert, states that her husband never willed to live in a vegetative life. Regardless, the court decided that there was no violation of Article 2 and 6 of the ECHR, hence the wife is not permitted to terminate his life-sustaining measures.
In contrast, Dutch law permits euthanasia under the condition that the suffering is unbearable as protected by Article 2 of the Termination of Life on Request and Assisted Suicide. The review procedures. Act which states that as follows. First, the requirements of due care referred to in Article 293, second paragraph Penal Code mean that the physician holds a conviction that the request by the patient was voluntary and well considered, holds a conviction that the patient's suffering was lasting and unbearable, has informed the patient about the situation he was in and about its prospects, and the patient holds a conviction that there was no other reasonable solution for the situation he was in. For example, he has consulted at least one other independent physician who has seen the patient and has given his written opinion on the requirements of due care, referred to in parts A till D, and has terminated a life or assisted in a suicide with due care. Thank you for your attention.
Hopefully this video provided you with sufficient information about euthanasia.
References should be followed next.